housing matters are heard in different venues in this city, but they're mostly heard in the landlord-tenant part of the Civil Court of New York. And just so that you get sort of a sense of sort of how busy it is, in the Bronx, regularly there are about 100,000, if not more, cases that are filed, most of which are evictions. And the one that you see behind you, the building, is Kings County or Brooklyn Housing Court. And the reason that I sort of put that in the background is that I sort of cut my teeth. I sort of began practicing in Brooklyn. When I started out doing this in 2013, you really didn't have a lot of tenants who had attorneys. It was sort of like a very sort of standard practice. And then the pandemic happened. It really sort of changed things so much that I really had to relearn my job. And sort of some of the things that I want to talk about are some of the major statutes that affected sort of all of our lives. And I sort of want to make this as such where we can talk about the statutes in a way that we don't get too much into the weeds, and we sort of figure out some highlights that people can take away from themselves and share in their communities, so that people can defend themselves when they are facing an eviction. And I want to sort of highlight sort of these 4 statutes. And I do have sort of a 5th thing that I want to discuss, which I sort of labeled Urban Dictionary. For those of you that stick around, I promise it'll be a treat. But I really sort of want to focus on these 4 statutes. What is the Tenant Safe Harbor Act, CFPA, ERAP, and the HSTPA. The HSTPA is a pre-pandemic statute, but it nonetheless is one that is important, and even more so now in the sort of, I don't want to say post-pandemic world, but sort of in the post-height of the pandemic world, right? So I want to share this article, and I don't want to dwell, I suppose, too much on sort of life before the pandemic. But as I was preparing for this, I came across this article that I had found in the New York Times on the eve of 2020, which Nicholas Kristof had put out there as the best year ever, 2019. And I suppose, considering everything that sort of happened subsequently in 2020 and 2021, 2019 doesn't look like a bad year. But obviously no one expected sort of what was going to happen. No one expected sort of to have to sort of revisit things like the Spanish flu, which like happened obviously 100 years ago, and all of us became sort of experts on it subsequently. But it sort of highlights sort of the major sort of shift that occurred. And obviously we all, as a result of the pandemic, had to social distance. And in March, the courts closed. And I'll never forget I believe sort of the specific date in which the landlord-tenant part of the civil court closed, which was March 16th. And the date sort of stands out to me because it was the day before St. Patrick's Day. And I had sort of really sort of had the illusion of sort of celebrating St. Patrick's Day. Unfortunately, the pandemic got in the way. But in March of 2020, the courts closed, and that really sort of brought a standstill to all of the courts, and landlord-tenant in particular. Cases were postponed, were suspended, were stayed, and the sort of the period in between March and June of 2020, not to give too much of a history lesson, was really a period of time in which we sort of saw the governor sort of exercise a lot of powers, and especially through executive orders. And it was mostly through executive orders that we initially sort of began to experience the stays in the court and in evictions. And that was obviously a very scary time, particularly because of sort of everything that was going on. For those of us that remember, sort of seeing the hospitals as they were backed up, to have to worry sort of about our shelters being overrun and the massive amount of evictions. A few months after that, in June of 2020, the Tenant Safe Harbor Act was signed into law, right? And this is sort of the first of several sort of pieces of legislation that were issued and were made part of the law that had a really huge impact on the practice of landlord-tenant law, right? And the Tenant Safe Harbor Act, as I pointed out, was signed in June of 2020, and it more or less was a compromise that allowed the following, right? It allowed for the issuing of a possessory judgment, or rather preventing the issuing of a possessory judgment or a warrant of eviction against tenants that suffered a financial hardship during COVID-19. Now, that sounds really good on paper. What possibly does that mean? Well, what it means is that you're not going to get evicted for rent that accumulated during the COVID-19 period. And the COVID-19 period was initially started to run March 7th of 2020. So that means that, you know, if March and April and June's rent came due in 2020, you know, you weren't going to get evicted. Your landlord was not going to be able to go get a marshal and go get a warrant to be able to evict you for that amount of rent, right? Now, that didn't necessarily mean that you didn't owe it. It just simply meant that your landlord couldn't go and get a marshal to evict you for it. They could go maybe to another court and sue you for it, and maybe try and, you know, chase you in your credit and in your history to figure out a way to get that money back, but they wouldn't be able to evict you. And that was thought to have been sort of, you know, a nice sort of compromise in which people would not necessarily forget their obligations, but they wouldn't have to face the repercussion of being evicted for it. And the key thing was that you needed to show a financial hardship. And there were, you know, there was a list of factors that you could sort of put forth, including your income, right? There were a lot of people during that period of time that filed for unemployment, and, you know, filing for unemployment in 2020 was a nightmare for many reasons. You know, it took sometimes weeks, months, but if you filed it and you were able to sort of get proof of your benefit, it was something that showed a reduction in your income and could show that you had suffered a financial hardship during the period of time, right? And so the Tenant Safe Harbor Act was beneficial in that way, and subsequently it was extended, at least the COVID period, not from March 7th up until January 15th, 2022. Now, I know that sort of seems like a long period, and you sort of might ask, like, well, you know, March 7th, 2020 and April 2020 seem like a really long time ago. And they actually do, I guess, considering sort of the collective experience we've all had. But the thing is that as a result of the executive orders that were signed into law and the other orders that the courts themselves allowed for cases to be suspended, is that we have still a backlog in the courts, right? We still have cases that have old index numbers from 20 and 21, that this very much benefits people, right? So if you're able to show that you suffered a financial hardship, you can go to court and show that you shouldn't be evicted for that amount of money, right? You still owe it, but you're not going to necessarily lose your home for it, okay? And what the courts can do is that they can sever it and issue a different judgment for it. And I know that might sound necessarily maybe a little sort of complicated, but strangely, as most things in housing court, we sort of figure out a way to sort of make it neat or unneat, but workable. So that's the Tenant Safe Harbor Act, which, as I pointed out, is still useful because the COVID period was extended to January 15th, 2022. The next thing I want to sort of highlight is the CEFPA law, which was abbreviated to the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020. And as I had pointed out, the courts closed in March of 20. Executive orders were issued by the governor that suspended and stayed cases. Then we ended up getting the Tenant Safe Harbor Act, and if folks remember, there were sort of huge ebbs and flows in what was able to be done in the country and in the city in particular, in terms of the normal operation of things. And so we began getting some cases throughout the summer of 2020, but because of the ebbs and the flows, there wasn't really much going on. And then at the end of 2020, there was this law that was passed, and this was really sort of a real sort of sea change, right? Sort of like a pretty significant law, and not to say that the Tenant Safe Harbor Act was not a significant one, but this one was one in which if it introduced something that was called the hardship declaration, right? And what the law allowed, among other things, was that if you had suffered a financial hardship, like the Tenant Safe Harbor Act had envisioned, you could fill out this form, which was a hardship declaration, and you could check off a box to state what sort of hardship you had endured during the pandemic. And it could have been economic, financial. There were also boxes relating to if you had undergone increased expenses and other effects of the pandemic. And if you filed this hardship declaration, you were able to stay your case, right? The thing was with the hardship declaration was that you yourself could not, it couldn't be challenged necessarily. And what ended up happening was that this law, SIFA, ended up going all the way to the Supreme Court in a case that we had as a plaintiff, I believe, Christophas, that ended up tearing down or invalidating part of the law. Now, I'm not going to get sort of into the specifics and sort of bore everyone sort of as to sort of what the Supreme Court sort of said about it. But it said that landlords were entitled to challenge the hardship declaration if you had suffered or endured a hardship during the pandemic. Now, the reason that I sort of point out this hardship declaration is that the hardship declaration, despite the fact that the law went up all the way to the Supreme Court and was invalidated, it is important today because it serves as prima facie evidence of your hardship. And if there's sort of something that I sort of enjoy anytime I sort of do a sort of a chat like this or a conversation like this, is to sort of throw out any Latin. Fortunately, no Spanish, but some Latin. And prima facie being sort of your case sort of on its face. And that's still relevant today. So I think it's sort of at some point there were something like 30,000 hardship declarations that might have been filed sort of at its height. I sort of remember sort of at the height of this, sort of just mailing out hardship declarations to all of my clients and to all of our office's clients and really sort of trying to get them out there, not attempting necessarily to do anything fraudulent, but certainly trying to alert people to their rights as to them. And, if you were able to check off the hardship declaration, you got your case stayed. But even sort of after the case went up to the Supreme Court challenging the law, it still serves as prima facie evidence that you suffered or you endured a hardship during the pandemic. And that can help you or can help sort of litigants say that they shouldn't be evicted for rent that accrued during the COVID-19 period, which again is that period from March 2020 through January of 2022. Okay. Now, the one more thing that I sort of want to highlight about this law, and this is something that is going to be sort of a little technical, but hopefully, we can sort of work through it for those of you that don't know landlord-tenant law very intricately, but is nonetheless interesting. And that is sort of the service of the papers during the COVID, sort of the height of the COVID period. There were added requirements as to how you were served with your papers. And in housing court and in most sort of other venues, but in housing court especially, you are to be served with your papers, at least pre-pandemic, in one of three ways. One is personal, The other one is substitute, which means you can sort of leave it someone and then put it in the mail. And then the other one is affix and nail, which is if you slide it under someone's door or put it on someone's door and then mail it, well, then that's fine with some exception. This law, what it ended up doing, the SIFPA law, was that it added a due diligence requirement. And what that sort of meant, I suppose, for those that aren't necessarily sort of as geeky and obviously sort of as experienced as I am in this, is that if you were served with papers and you're in housing court right now for a case that was filed in 2020, 2021, or even 2022, is that you should absolutely challenge the service, because there's probably more than a 50% chance, I think, and I only sort of say this like anecdotally, that the service was not correct. And among them was this due diligence requirement that was imposed by SIFPA, that second law, for how the papers needed to be served, right? And the thing was that previously, if you wanted to do one of those three services that I pointed out, either substitute or conspicuous, the nail and mail service, was that if you attempted, or the process server attempted on 2 occasions to perform the service, that was fine. But what some cases found during the COVID period was that attempts on 2 consecutive weekdays didn't satisfy that, right? And so I know that this is sort of very, very sort of intricate, or maybe not so much. But the point is that if anyone has a housing court case that you were served with papers during the height of the pandemic, you should definitely challenge it. And the due diligence requirement is something worth discussing. Now, I'm going to get in a little later about the right to counsel law, as to how a lot of tenants these days have an attorney and access to counsel that can probably sort of sift through this, but just sort of pointing this out as something that I think folks should know to begin with. So sort of to back up again, right? So we had the Tenant Safe Harbor Act in June of 2020. We had SIFPA at the end of 20. And then subsequently, we ended up getting the ERAP program, right? The Emergency Rental Assistance Program. And as all things that are done by the government, this was something that was very promising and took forever to get off the ground. However, it was a program that was awarded a lot of money initially, and then subsequently, I think, had other rounds of money. Excuse me. And it pretty much allowed a tenant or even folks that were didn't necessarily have the strongest of tenancy rights, we can sort of get into that later, the ability to apply with the state through this program to get some of their rental arrears paid, right? It was, I think, initially 12 months with 3 prospective. And a lot of money was issued, a lot of money was dispersed. And actually sort of I believe one of the interesting things about this program was that when it was initially issued, there weren't any questions concerning your legal residency in the country, which was something that was sort of very satisfying for a lot of advocates, seeing as particularly during the pandemic, you had a lot of people who were undocumented, who were really sort of out there on the front lines, making sure that our groceries and sort of every little thing was sort of taken care of. It was certainly something that was heartening and sort of made a lot of us happy. Notwithstanding, the program, what it did was that while the application was pending, program was administered by OTDA, is that it stayed most cases upon the filing of your application, right? And the application itself, as most things run by the state, it was definitely sort of a very interesting process. initially. It did have at moments sort of difficulty getting off the ground, but eventually sort of advocates got in the flow of it. And the point of it was that the cases in housing court were stayed as a result of you filing the application. Now, there was a deadline that just passed a few months ago. That was the January 2023 deadline, in which no more applications were taken, but there were tons and tons and tons of applications that were filed. The state has moved along sort of rather quickly, or is attempting to get through sort of the remaining applications. But because there are still applications outstanding, there is a lot of case law out there concerning who gets the stay, who gets the cases postponed. And there has been some talk about particularly Section 8 tenants. The state listed priorities for those that were eligible for the program, and folks that were in Section 8 are getting FEPS, which is a local program, Section 8 being a federally administered one. Were put in the lowest sort of category, sort of what we call priority 5, or not what we call, but what the state ended up calling. And because they were put in a lower priority, there were a lot of questions as to whether or not they would get the benefit of the stay while the application was pending. And so what ended up developing was a little bit of a futility sort of argument that was drafted by the courts as to whether or not, excuse me, tenants would get the benefit of the stay, right? I don't necessarily sort of want to sort of get too much into the weeds about this. I mean, I could sort of talk about this sort of all day, obviously, because it's sort of the work that I do, and sort of I follow up on this. But there was a lot of talk as to who should get the benefit of the stays of a ERAP application if you weren't a tenant, because as I pointed out, this was a program in which this was very much to the benefit of landlords, and it sort of did away with a lot of things that previously had been issues, namely, or among them, namely, your status here in this country. That was something that was not sort of minded, and no one sort of really was sort of paying attention to. And so you had a pretty big pool of people who were applying who maybe didn't necessarily have the sort of the clearest of tenant rights. And so there was a lot of sort of back and forth about it. But what the courts have really sort of tried to do in terms of determining sort of who gets the benefit of the stay, sort of the particular circumstances of the proceeding, right? And I think sort of what the courts are mostly sort of worried about, if you are someone who's attempting to succeed or maybe has lesser rights than a tenant, is whether or not sort of in sort of going through this application, a tenancy will be reinstated or a tenancy will be formed, whether or not it's sort of futile, whether or not it's sort of absurd to sort of allow sort of these motions to go through, right? So that's sort of something that's like a very hot topic right now. And despite the fact that the program is, I think, winding down, there is sort of still talk as to sort of whether or not this is absurd or whether or not it's an act in futility to allow this stay. Of course, some would say that a lot of housing court is futile. I'm kidding. Notwithstanding, I also wanted to go on a little bit more about sort of provisional approvals. So normally, if you're applying for ERAP or if you apply for ERAP, again, because the deadline passed, you initially would get sort of a provisional approval, and there was talk as to whether or not the stay of the proceedings would continue to be issued and allowed if there was a provisional approval. It sort of depends on sort of each and every judge. I think a major sort of concern about the courts is trying to get through these backlogs which have been pretty substantial since the pandemic. And this is the fourth statute that I want to get to. This is the HSTPA. So as I had pointed out, with the start of the pandemic, we ended up getting the Tenant Safe Harbor Act, which allowed people to not get evicted for rent that accrued during the financial or what was deemed the COVID-19 period. The second statute was the SIFPA, which allowed people to file the hardship declarations and allowed for an increased service requirement for papers filed. ERAP, which was this program that was created to issue large sums of money to landlords and allowed for stays to be applied. And then this statute, which preceded the pandemic and was issued or made into law in the summer of 2019. And sort of the things that I want to point out here are sort of more service orientated. I don't want to bore people too much with sort of the details of the RPAPL, but the point is that a lot of landlords were very sort of desperate to get into court because of sort of everything that was going on. And what they would do, particularly with holdover proceedings, is that the date and time listed, they would sometimes put to be determined. And that's something that's sort of a red flag. Like I pointed out, sort of the due diligence thing previously, where you maybe should be sort of a little wary as to sort of how many times sort of your landlord's process server came and allegedly knocked on your door before slipping the service under your door. You know, if the petition itself has a to be determined sort of portion in the notice of petition and in the papers, that's sort of a red flag, because that was something that sort of isn't allowed by statute. And there was some confusion as to it, but you know, these are little things that you could sort of see, particularly now that people are in court, that could allow someone to maybe a little bit more leverage in negotiating a better settlement or just even getting the case dismissed. So again, you know, if there were to be determined sort of signs and portions on the papers that you were served with, that's sort of a red flag. The other thing is the RPAPL states that, I beg your pardon, in a non-pay, your landlord is supposed to serve the affidavit of service 3 days after the papers are filed. Sort of something to sort of also sort of be wary about. You know, if sort of you take anything away from this, is that the pandemic was really you know, a sea change and changed a lot of things. But if there's something that you should definitely be aware of and challenge constantly, is the service. There are a lot of things that were emphasized, that were changed, that can get a case dismissed because of the failure to serve. Okay, and you know, all of these little things I think sort of make a difference. Moving along, I promise to be done sort of in a few more minutes. I also sort of wanted to get to this change, which was the RPAPL 753-1. It used to be in housing court that you were allowed up to 6 months to move if you decided to vacate an apartment. That was changed in 2019 to up to a year. But obviously, with this pandemic, things have changed pretty dramatically. And the point is that there is certainly an argument, and sort of an argument that has been elaborated further, in which you know, the 1 year rule only goes to staying the issuance of a warrant, and that because of sort of everything that's gone on in the interest of justice, that stay should possibly be, you know, increased from up to what it was a year. No current rent provisions. I just also want to sort of point out a few more things, sort of, I guess, before we close. I want to talk about sort of a little bit about adjournments in housing court and right to counsel. There was a big sort of push in a law that was put in to try and afford tenants a lawyer if they faced an eviction proceeding because of the pandemic and because of, you know, backlogs and even some staffing issues. That's been sort of difficult to implement. But notwithstanding, you know, I do want people to know that there are efforts to get people counsel, and in addition to that, that you are allowed in adjournment to get counsel. Right now, it's not necessarily a courtesy. That this is the law, right? And that's sort of baked in there. So you know, if you go to housing court, you're facing an eviction proceeding. Please know that you do have an adjournment that you are entitled to, that you can get to seek counsel, to connect with a lawyer, which is something that the courts are trying to do, and that you're not going to get evicted on your first appearance or anything of the sort. And finally, I guess the last thing that I'll sort of say before I take questions, if anyone has any questions, is I wanted to sort of make mention of the fact that you know, if you ended up getting your petition or the lawsuit and you ended up paying it as soon as you got it, you satisfied it, and that settles the case and that discontinues the case. And because sort of things were so much in flux and continue to be in flux, it's important to keep sort of memory of that, right? And to make sure that you keep your receipts and proof, particularly if you satisfied your arrears. And so I guess sort of in closing, what I'll say is, you know, please note that, you know, if you suffered a financial hardship during, you know, the last 3 years, you might not have to get evicted for the sort of rent that was accrued. And in addition to that, please challenge service as much as you can. There was a lot of choppy service that was performed, and you know, people shouldn't be getting evicted if they weren't served appropriately. So I believe we're at 6:50. If anyone has any questions, any comments, by all means.
Alberto, thank you so much. That was super informative. That was very informative. We do have 2 questions on this side. The first one is about COVID relief. So, you know, there's a big talk about long COVID, but a lot of the times people are asked for relief due to COVID was during those dates and periods. What about affected by COVID? Maybe it happened after the dates in those statutes. Is there any option for them?
I mean, the advantage I think a lot of people have is that sort of the window period is pretty long. You're gonna have to sort of sync it in with the period, right? And the period is more or less March of 2020 through January of 22. Yeah, and if you can bring it back to that, to those periods, you know, I think you can make an argument. Unfortunately, yeah, you know, past that period, the courts are not going to sort of make sort of the special exceptions that they were making for people. Now, that doesn't mean necessarily that if you owe rent, besides the ERAP statute, that there are other avenues for you to get assistance. Something that I think a lot of people sort of know about is the one-shot deal application that will assist you. I just want to point out, you know, the one-shot deal, it is assistance, but it isn't a grant, right? It's a zero interest loan, but the government does take into consideration circumstances like that. And because of sort of the difficulties that the state went through, they have been a little bit sort of more questiony, sort of, to put it like that. But if you're able to sort of, put together a case and a story after those periods of time, then I think you stand a pretty good chance of getting sort of relief in a one-shot deal.
Awesome, thank you. And I think the other question we have is about process and procedure. So if someone, for example, is having an issue with their landlord and the issue is non-payment, they're not paying their rent, and the landlord evicts them, what's their next step? And if they have, for example, a defense, for example, the reason they're not paying is because the landlord has not fixed something in the apartment or there are issues in the apartment, what would be the steps that they take once they first arrive in housing court?
So if you've been evicted, that was the question, right? If you've been evicted?
Yeah, well, the landlord is trying to evict them.
Okay, so let me just say that if you've been evicted, I know that wasn't sort of the question, but I just sort of want to point out, if you have been evicted, please, or anyone, make sure you go to court immediately. Usually the courts do a pretty good job of trying to hook you up with a lawyer. Strangely enough, or not, maybe not strangely enough, the government usually works a lot faster in sort of resolving your arrears. But if you are in the process right now of getting evicted and you haven't been evicted, then it's really, really important that you sort of take stock and notice of the papers that are served on you and don't ignore them. Go to court immediately. You're going to go to a window, probably depending on where you're at, to file an answer, which will give you a court date. And what's being done in most of the courthouses is that once you're there, they will try and hook you up with an attorney, right? Because of sort of staffing issues in a lot of legal services organizations, that isn't always successful. However, you will probably be given sort of a lot of advice as to what to do next. And sort of a lot of these defenses that I pointed out is something that you should sort of take stock of, right? Like even if you don't necessarily sort of have a deep understanding of sort of everything that I just said, take away this, right? There's probably a really good chance that your landlord didn't serve their papers on you correctly. And sort of just make an issue out of that. And even sort of the judges will take that seriously, particularly sort of in this period of time. The other thing is, I'll just sort of point this out, right, is that the ERAP thing, gave people 12 months max, 3 perspectives for a total of 15, which in a lot of cases left arrears. If you don't have sort of the remaining amount, you could probably piece it together in a one-shot deal, maybe charities, Homebase is a resource that's around. Try to piece together what you can, right? Like, no one's expecting anyone to sort of have, maybe necessarily $10,000 in rent, but if you're able to pay your ongoing rent, this month or next month, that's something that the government normally likes. And I would encourage, and listen, I know that it's eggs are like $100 these days. And, I guess it's really sort of not funny, but, if you're able to sort of show that you can do your ongoing, I think it'll take you pretty far.
Thank you so much. That was very helpful. I don't see any other questions, so I just really want to say thank you. That was very informative. And on behalf of the National Dominican Day Parade and Dominican Bar Association, thank you for providing this information to the community. That is what we are doing here, right? This was a joint effort to really bring information that is pertinent to the community and information that maybe, like you say, you do this every day, right? So this like the back of your hand, but most people still have questions and are confused when they arrive at housing court. So for those of you who joined us, thank you so much. This is one of many leadership series. Please go to natdp.com and view other series and join us. And Alberto, if you have any other last words or anything you want to say, this is your time.
Yeah, I guess sort of the only thing that I just want to say is I know that this is all sort of a very scary process, but I think as long as you sort of show up, you'll be fine. And the other thing that I didn't talk about, and I just sort of want to close, is if you do have repairs, please know that you can start a case against your landlord for the repairs. It is sort of a very useful tool. You do have to pay something, but if you can prove that you're indigent, which means that you can't afford it, they will waive the fee for you. And usually the court is very hands-on in sort of getting it done. So please keep that in mind as well.
Awesome. Thanks so much. Very helpful. Well, I think that is it for us. Good night, everyone. Thank you.
Uh,
Thank you, Marcel. Thank you, Alberto, too. I really appreciate you doing this. It's recorded, so I'll see if Marcelo can send it over to you too.
all right.
Thank
I
you.
appreciate it. Thank you. All right.
Thank
Good
you.
night. Bye.